And to get the bigger picture of what the Court of Appeal ruling means, Trevor Ombija spoke to constitutional lawyer Bob Mkangi and started by asking him the implication of the ruling on state officers.
Pronouncement and an announcement that the standard that Kenyans created in the Constitution is what is going to be upheld, and they have to function in their offices to that measure or with that measure, if not even better.
But now the Council of Governors argues that the ruling essentially cripples county functions. What role can governors continue to play while they're out there because they're not allowed to access office?
Definitely, there's that quandary of now what happens. These are elected officials. I mean, there's that balance that I'm sure the courts were trying to reach, and that's why the deputy governor, the position of deputy governor exists. Definitely there are certain issues, there are certain functions that are going to be affected, but I think with the limits that the Constitution creates, the acting governor, who is a deputy governor, is able to execute.
The Anti-Corruption and Economics Crimes Act says corruption cases must be handled within 2 years. Did the Constitution envision a situation where the governor is absent for more than 2 years and is not exactly incapacitated for the deputy governor to step in?
Well, in certain ways, and that's why even Kenyans created the position of the deputy governor. There are times when we've seen governors fall ill and their deputy governors step in. So the Constitution and this position of deputy governor, which again many Kenyans were asking before, and claiming that probably it's a useless position, but now we are seeing the importance of why we need a standby governor.
But I still see a lacuna there because they can't exactly do all functions.
Apart from appointing and firing, I think everything else that is important in executing the functions and responsibilities of a governor, those can be undertaken. So it's just in terms of making sure that the acting governor does not, effect let's say a coup by coming in and then changing, the executive as was created by the governor who is absent.
But that is for the deputy governor who actually exists. Nairobi now is a unique opinion, is a unique case. Will we then need a Supreme Court advisory opinion for Nairobi, for example?
I think it might get there if other authorities or responsible agencies do not deal with it. You can have Parliament that can look into the issue and see whether through an act of Parliament something can be engineered to take care of such an occurrence. But also we must look at it from the rights of wananchi in terms of being disenfranchised when the leader they chose to serve them is probably put out of office indefinitely. It also has that implication in as much as it is there to protect their right to proper constitutional service.
But doesn't this then ruling finally just bring a quandary of some sorts, and also an avalanche of cases where the deputy governors might just go to court to oust the governors because then they know they're the ones who come in next in line?
The fortunate thing is that we operate under rule of law. It's facts that determine what ends up in court. I mean, we've had all manner of accusations labeled against governors, but it's not all of them that have ended up in court. Yes, the chance is there, the jeopardy is there. I mean, it's politics, it's life, where an ambitious deputy governor would feel that maybe this is an opportunity to rise to the occasion and to be the governor. Fortunately, there are other avenues, legal avenues that exist that will ensure that it's not through imagined and speculated cases that governors are put out of office.